CBS News Special Report. Good morning, everyone. I'm Major Garrett. We're coming on the air with breaking news from the Supreme Court, where the justices have just ruled on whether former President Donald Trump has absolute or qualified immunity for conduct involving his official acts during his time in the presidencies. The former president and his defense team made the argument that a president, not only former President Trump, but any president, has absolute immunity. This after he was criminally charged with plotting to overturn the results of the 2020 election. The import of this case simply cannot be overstated. How the justices rule could well define the parameters of power of the American presidency and have something to say about the future of our very democracy. CBS News chief legal correspondent Jan Crawford has been reading the ruling. Jan, what do we know?
We know this is a 6-3 ruling written by the Chief Justice that says flatly presidents are immune, absolutely immune for their official acts. That means acts that they take under the arbit of their office as president. But, and here's the big but and why it's important for Donald Trump, they do not have that kind of immunity, as you said, for their unofficial acts. So then what does that mean? What is an unofficial act? And the court, in its opinion, gives some guidance on how the courts can draw those lines between official conduct and unofficial private conduct that a president can be prosecuted for. There is a scathing dissent by Justice Sotomayor, joined by the two other liberal justices. This is not an outcome that John Roberts would have preferred, saying that she is now fearing for our democracy. So we, again, are just getting this opinion. I will be reading how the court has drawn this line. Based on what I'm seeing in Roberts' decision so far, I do not believe right now the court has closed the door off to prosecution of Donald Trump for those unofficial acts, as the lower court had outlined in a separate case. But there is guidance in here, and Major, we're going to have to take some time to look at that.
So based on your initial reading, Jan, you do not interpret this ruling as foreclosing Special Counsel Jack Smith's prosecution of former President Trump on evidence and charges related to January 6, 2021.
If what the guidance they say in this opinion right now suggests that some of that behavior is an unofficial act, which is what Trump's own lawyer conceded during the oral argument, a number of things in terms of submitting fraudulent statements to court, submitting fraudulent states of electors, he conceded those were private, unofficial acts. So based on this quick run through, that suggests those still could be possibly open to prosecution. However, I also want to look at Justice Sotomayor's dissent. She was not on board with this at argument. She believed that even having any immunity whatsoever was dangerous for the country, that there were other ways that presidents, our democracy could deal with that, and that we didn't even need to be getting into this. So at the very least, we need to look at that.
Jan,
but right now, these are the two lines. It's what we expected between official and unofficial.
In a broader context for the court itself, it's a fraught moment for the court. Much of its public interpretation has suffered in the last couple of years, people finding it, to their point of view, more political than they are comfortable with.
Well, no question.
And in that atmosphere, a 6-3 decision on a matter of this import, how does that land with the Chief Justice? How do you think that will be absorbed by the country at large?
This is not the decision that John Roberts had hoped for. I mean, he would have hoped for a unanimous decision similar to what we had in the Colorado case when the court ruled almost unanimously, and certainly in the judgment, that Donald Trump could not be removed from the ballots in states. That is what they would have hoped for in this case, and even in the case on Friday, when a case that did not directly involve Trump but will affect his trial on whether he can be charged with obstruction of an official proceeding, one liberal joined with the conservatives. This one is straight ideological lines. You've got a very fierce dissent by Justice Sotomayor, joined by Justices Kagan and Jackson, suggesting that what the court has done today is potentially dangerous for democracy. That she is, and if you just go to the last line, I just had skimmed it. She is fearing for our democracy. She is dissenting. That is very charged language, very unusual.
Jan, I'm going to let you continue to read. Scott McFarland, I want to turn to you because this decision was waited for by the nation, but specifically here in Washington, D.C., by the special counsel and his team and the district federal judge, Tanya Chutkan. What do you imagine this ruling will do to the calendar as it's understandable this morning for that case, January 6th, and former President Trump?
The bottom line has always been, can they get a trial in before the election? before November 5th. As the court spent all this time reviewing the matter, the prospects dimmed. It was a long shot going into this day, like drawing an inside straight at the poker table. Based on the initial read, it looks like it's a longer shot, like winning the lottery, because some of this has to go back to Judge Chutkan, the district court judge who's been assigned the trial, and she may have to go through what's an official act, what's not an official act in the indictment. That's going to cost more time. That's going to cost more hearings. It's going to cost more bandwidth in a courthouse where they had just a narrow window to work with in the first place. Judge Chutkan has already said when she gets this case back, she's going to give both sides 2 to 3 months to get ready for trial. So if it goes back to her today, there's 2 or 3 months she's going to give both sides anyhow. That brings you into September, maybe into October. Now there are a whole bunch of bear traps that the Supreme Court may have set for her that slows things down more, where she has to go through hearings, requests from Trump's team to stay the proceedings further. Really looks like the longest of long shots to get any part of this trial in before November 5th.
Scott, you've been in the courtroom a lot. You've watched the entire progression of this case. I've listened to and read some legal experts saying if the court does, as it did, there were some who interpreted this in advance, this ruling, there might not be a trial, but there might be a pre-trial hearing in which evidence not known to the public yet, but presented to the grand jury that formed the basis of the indictment might become aired in full public view. Is that a possibility as you see it?
It's an intriguing thing. Judge Chutkan could order a hearing on one of these matters. Was it an official act? Was it an unofficial act? And at that hearing, the special counsel could present all kinds of evidence with which we're not familiar right now. All kinds of revelations, maybe witnesses from whom we haven't heard. So maybe no trial, but maybe there are things America could learn through one of those hearings. Maybe it could be theatrical. Put that aside. Judge Chutkan has done something over the course of this case that's noteworthy. She has been crisp with timeframes. She has moved diligently through all of the hurdles Donald Trump's legal team tried to erect to slow down the case. She moved nimbly early in this case, and she has said in so many words that democracy remains at risk. She has said that during January 6th sentencing. She has been unequivocal in stating what's at stake when you talk about January 6th.
The hardest job at this table is carried out by Robert Costa, our chief election and campaign correspondent. I don't want you to give me the instant analysis, but how do you think this ruling, based on what we know so far, Robert, will land in Trump world? How will it be characterized? And what do you think, at least initially, the political impact is probably to be?
It's important to step back and look at the full context politically here facing former President Donald Trump and his campaign. This Supreme Court and its ruling on presidential immunity is just one front in a multi-front challenge they are confronting as they head toward the November elections. On the federal level, as Scott has been detailing, they're looking at a possible trial on January 6th. But in terms of unofficial acts, as we've been discussing here at this table, there's also a possible looming federal trial on Trump's handling of classified materials. Now, that has been a bit stalled in the process down in Florida, but that still is a possibility of being a trial that confronts the former president, maybe not before the election, but at some time in the next year or so. And let us not forget, too, that former President Trump on July 11th faces sentencing in his criminal case in New York over those so-called hush money payments made to porn star Stormy Daniels. Trump has been convicted there. And what's happening with immunity on a presidential level with the Supreme Court is, as Jan would often detail, about federal cases. It's not going to affect what the judge, Juan Merchan, decides to do with sentencing in New York. And then you, of course, have the Georgia case that could play out at some point later this year or next year about election interference allegedly committed by Trump in Georgia. So all of these cases hover over the Trump campaign. They may feel heartened by the Supreme Court's ruling today to a point, but this is by no means the end of what they face legally.
It does not lift the cloud of legal jeopardy.
That's exactly right. It does not lift the cloud at all. And in fact, even if former President Trump feels like he's getting the weight off his shoulders on a federal level with special counsel Jack Smith, there is still a real possibility that he faces a possible jail sentence this year, or probation, or house arrest to some extent. And that could happen at some point. That could affect the Republican National Convention in Milwaukee.
Days before the Republican National Convention.
July 11th is the sentencing date. The Republican National Convention starts the following Monday.
We promised you that Jan would continue to read and sift and analyze. Jan, what can you tell us?
Well, I mean, I think the bottom line is that the Judge Chutkan's going to have a lot of work to do. And they're giving her standards, setting out things that they believe.
Would you describe it as a roadmap, something that clear, or something a little bit more vague?
I think it's more clear, but it's still going to require fact-finding, hearings, briefing, which means time, clock ticking. So, obviously, the court is saying there are some things that sound official, like communications with the vice president that presidents have, even if you're, running for office. Some things may be unofficial, which, again, we mentioned earlier is what they ran through at the argument, that the president's conversations with outside people. And then there are some things, is he doing it as a candidate as opposed to doing it as president? But again, it's evidentiary hearings, it's fact-finding, and that's going to fall on Judge Chutkan.
Can I just build off
yes, go ahead, Robert.
Jan's point for 1 second? One of the key witnesses CBS News has learned for the possible January 6th trial is former Vice President Mike Pence.
Correct.
And his aides. And if vice presidential communication with the president necessitates an official act, that could gut, potentially, Special Counsel Jack Smith's case. Because remember, one of the key moments of January 6th is the night of January 5th, when Trump brings Pence into the Oval Office one-on-one and pressures him again and again to overturn the election. And Pence says, I have a constitutional responsibility to certify the election.
One thing there, Robert,
But
that's
the argument would be that some of those conversations weren't official conduct.
Weren't official
right?
conduct because...
So, again, this is going to fall,
even in the Oval Office.
I mean, that may not necessarily be official. I mean, it's a pretty high bar, but...
As we debate this here at the table, I want to bring in Jessica Levinson, CBS News legal contributor and Loyola Law School professor. Jessica Levinson, if you can, jump in on this question. So the president is having a conversation about the Electoral Count Act and certification with the vice president. The Electoral Count Act is a law. It has been passed by Congress. The president is duty-bound to follow that. If he tells the vice president, even if it's an official conversation, to somehow subvert that, what is that? Official act or private act?
So everybody's going to hate this answer, which is it depends. I think Jan has laid this out really well. Let's remember. So for the things that are just for the president, for those things that are just within the president's ambit, absolute immunity. For official acts in general, at least presumptive immunity. For unofficial acts, no immunity. So we have these three categories. And then the question becomes, and as Jan said, this is going to be the question for Judge Chutkan, how do we put information into those buckets? And Major, you just laid out one of the big questions. And so what we know from the opinion thus far is that we put meat on the bones of these standards by saying, does the president have the constitutional and statutory authority? That's what Roberts is starting with. Like, who gives him or at some point her the authority to act in this situation? And if they're acting pursuant to that authority, then that's something that a president can do, and that would mean it looks official. If it's something that you or I could do, if we could have a conversation with a private attorney and say, you know what, I think we should file this lawsuit, or if I could call a governor or a secretary of state in a capacity as a candidate or a private citizen, then it starts to look unofficial. So I know everybody wants, here is the answer, but I have to say, looking at this particular opinion, it really depends on looking at the Constitution, looking at the statute, and then looking at the facts of, frankly, a specific phone call. I heard Jan use the words, evidentiary hearing, looking at the circumstances. I could not agree more.
It depends.
And again, following up to Bob's point, because that's so important, and it's what Jessica, and if you want to weigh in on this too, I mean, the court is saying, as far as those communications with the vice president, they're not ruling out that those could potentially be unofficial acts, but it's going to fall on the government. It will fall on Jack Smith to rebut that. He is going to have to show that potentially those conversations that he had with the vice president, when he does have no role in the certification, Trump did not, whether that would fall outside that official conduct.
Falling on the shoulders of the government. We are helped at this particular moment by having former Justice Department prosecutor Tom Dupree join us. Falling on the shoulders of the government to parse the wording and the import, the meaning, the gravamen, if you will, of this Supreme Court opinion. Tom, as a former federal prosecutor, how do you read it?
Well, look, I can't imagine that Jack Smith is super surprised by this decision. This is definitely the way the Supreme Court majority was leaning based on the arguments. And I think the takeaways are twofold. One is that Smith has to be heartened, at least that his prosecution will survive. The Supreme Court did not accept former President Trump's argument that immunity requires the prosecution to be shut down entirely. So he'll live to fight another day. Second point, this is a homework assignment of massive proportions for Judge Chutkan. There is an enormous amount of legal work that is now going to have to unfold over the next several months. That means the chances of a trial before the election are zero at this point. So although his prosecution survives, it ain't happening anytime soon, at least as far as a trial is concerned.
Jan, you have some very important language from the dissent.
Right. I mean, as we were talking about,
Sotomayor.
Justice Sotomayor, joined by Justice Kagan and Justice Jackson, the court's three liberals, as we were saying, it's fiery. I just thought I will give you some examples.
Please.
Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle foundational to our constitutional system of government, that no man is above the law. And this was an argument that she made during the oral argument. She was very hesitant to embrace any kind of immunity for anything, suggesting when, say, Justice Alito was talking about how a bitter campaign and the winning candidate could then throw the loser into jail. They were very worried about the impact on future presidents. And as we saw in the debate, Donald Trump did suggest that Joe Biden's immigration policy was criminal. So perhaps under a Trump DOJ, if there was one, could he throw Biden into jail if he is the winning candidate? The court was worried about this Pandora's box of future prosecutions for former presidents. Sotomayor was not. During the argument, she says, if we come to that point, our democracy has failed. And there are other ways to address it. So this dissent tracks very much with what she argued. What I find notable is that Justice Kagan joined it, as well as Justice Jackson.
Tom Dupree, very quickly, as someone who knows well the hesitancy the Justice Department has always had in the question of prosecuting former presidents or even sitting presidents, how do you regard that dissent? Do you consider that, well, just what's your opinion of that dissent?
Look, I think this is a case where both the majority and the dissent were grappling with very powerful arguments for their side. On the majority's side, they, I think, very legitimately were concerned about the threat of future presidents possibly being prosecuted, just as Trump threatened during the debate. On the dissent side, the principle that no American is above the law is about as hallowed as you get in our constitutional structure. So I think Justice Sotomayor's concern definitely has force. I think if you're a prosecutor, you just kind of dust yourself off. You keep going. You've now been given this guidance. I think the Supreme Court gave surprisingly specific direction to Judge Chutkan as to how this case needs to move ahead. It's more than I anticipated they would provide. And so it does give maybe not a roadmap, but a general directional indicator as to the way that this case has to move ahead now.
Robert Costa, reaction from former President Trump.
This is an explosive political moment, as much as this is a significant legal crossroads. Former President Donald Trump has just reacted on his social media site saying, quote, "Big win for our Constitution and democracy, proud to be an American." There's a lot of celebration clearly happening in former President Trump's orbit because, as we've been discussing, he might not now face any sort of federal trial before the election. And the political moment here also needs to consider what it means for Democrats. This comes just days after a presidential debate where President Biden was widely seen by members of his own party as failing to hold former President Trump to account on numerous fronts, seen as stumbling on the debate stage. There has been talk about what's next for President Biden. Now, Democrats potentially could be galvanized against this Supreme Court behind President Biden because there's so much anger going back to 2022 and the overturning of Roe v. Wade. Now they see Trump's escaping trial likely this year. So you have a charged political moment right after the Democrats had this reckoning in Atlanta.
Let's talk about that. Galvanized Democrats' future of President Biden's reelection campaign. No one better to help us do that than Chief White House correspondent Nancy Cordes on the North Line of the White House with reaction from the Biden reelection campaign. Nancy, please.
Major, they're still absorbing this ruling here at the White House and at the Biden campaign, just as you have been doing around the table. But I do have, as you point out, some early reaction from a senior Biden campaign advisor who says, quote, today's ruling doesn't change the facts. So let's be very clear about what happened on January 6th. Donald Trump snapped after he lost the 2020 election and encouraged a mob to overthrow the results of a free and fair election. This person goes on to say, since January 6th, Trump has only grown more unhinged. He's promising to be a dictator on day one. Joe Biden will make sure the American people reject him for good in November. Very interesting use of words in this statement. Snapped. He's grown more unhinged. It's almost as if they are trying to suggest that despite Joe Biden's weak performance last Thursday night, that he is not the one who is deteriorating. It is Donald Trump who has snapped, who is growing unhinged. He is the one who is falling apart. There's no question that the Biden team would have loved for this trial to take place before Election Day. I think they've been resigned for quite some time that wouldn't happen. And now this ruling, as Jan has pointed out, has all but closed the door on that.
Scott McFarland, you have muted reaction from the special counsel's office.
Yeah, Jack Smith's office is not commenting on the Supreme Court ruling, which means he's not laying out a roadmap ahead for his case. He's taken the same posture during previous rulings involving Donald Trump. But it's also important to note that Judge Tanya Chutkan does not have limitless bandwidth, time, or space. She has other matters in her court. And I was just in her court last week for a few January 6th defendant sentencing hearings. She has a trial the week of the election of a January 6th defendant. All these judges are quite busy navigating these 1,400 plus U.S. Capitol riot prosecutions. So if it takes a lot of time and space to go through all these matters with Judge Chutkan, this can bleed well into 2025. But I'll also admit that I'm getting any number of text messages, I suspect you guys are too, from Democratic staffers, operatives saying, what would this ruling mean if Donald Trump wins the White House back? What would this mean for his presidency, this jolt of presidential immunity?
Jan, if I could ask you, we have duly noted the stinging dissent of Justice Sotomayor.
Oh, let's just give some more. I mean, I'm just reading this.
Can I ask you what?
The president is now a king above the law.
Okay.
That's her bottom line in her dissent. Sotomayor.
Wow. And
in
the majority.
In every use of official power, the president is now a king above the law.
And if you could summarize the majority's opinion.
Putting
together this.
I'm reading Roberts now. I mean, he is just basically saying that's ridiculous, despite the dissents, rejecting all of this, what they believe is very reasonable analysis. The president is not a king above the law, and they have certainly still some immunity, ability to be prosecuted for these unofficial acts, which I agree with Tom Dupree, and I am surprised there is more of a roadmap here than many people may have thought. I still think this means delay, and it's going to take Chutkan time, but they have given her more to work with on what does and does not constitute official acts that Trump cannot be prosecuted for. But there are still things in this indictment that Jack Smith is going to, and I would guess he anticipated this ruling and he already has his papers ready to go, is going to say there is enough in this opinion that says we can still go forward with this trial.
Scott? It's quite possible during some of these hearings, some of these matters that go back to Judge Chutkan, that Donald Trump might have to be there in the courthouse for them. He is a criminal defendant, and it is a criminal case matter. It's less clear to me that it's necessary in all cases, but you do have the prospect sometime before the election of Donald Trump walking in to the Washington, D.C. federal courthouse, or more likely being shuttled underground through a private entrance for a criminal matter in a federal criminal case. These hearings do give the special counsel the chance to make some type of argument about what he says Donald Trump did.
And I agree. But I also think, and to your point about, some of the reaction from what we've heard from Trump already, I mean, this is a win for Donald Trump. And I do see, based on this ruling, it seems very difficult that there will be a trial this year.